Welcome, Professor Masako Kamiya, to this Angel interview series. First of all, for our viewers, would you be able to introduce yourself and your areas of research interest?
Well, at the moment, I'm teaching at Gakushuin University in Tokyo as professor of law, and I teach Anglo-American law in the university for the undergraduate as well as graduate students in law schools. And yes, my actual interest is the role of the Supreme Court in different countries, especially of how they have been, the relationship with the other departments of government, but as well as within the judicial system, how different Supreme Courts has been functioning in different ways. But that's really a big topic. So usually I look into the cases that a usually American Supreme Court or the English Supreme Court would have decided, and how it relates to my interest in terms of the function of a Supreme Court. But I had been involved in different projects, especially I'm a member of the board of several NGOs, and one is the Japan Civil Liberties Union, and another one is a entity called International Women's Year Liaison Group in Japan. And the latter actually promotes the status of women to, what should I say, establish a gender equal society in Japan. And that sort of reflects into some of my interest in looking into women in Japan and their sort of legal status or the change that had happened to them within the last 70, 80 years. Okay. So that's what I do.
Okay. So you've been one of our long-standing teachers in the Kyoto and Tokyo seminar series, co-sponsored by Angel and Ritsumeikan University. Can you tell us a little bit about what you've taught in that program?
It was a really interesting to teach about women or gender in law in Japan. And usually I focus on the history of women getting rights in Japan, starting with 1945, 45 or 47. And also I talked about what the Equal Employment Opportunity Act meant, or what it was designed to do in Japan, how it had sort of transformed into what it's now trying to be sort of gender equal act, as opposed to, should I say, trying to upstage a very inferior women's status within the workplaces. So in the beginning, it was just to put women in its not really equal footing with, but try to present women as a co-worker within the workplace. But now it aims to provide for both men and women in workplace for equal opportunity.
Okay, so let's talk then about equal employment opportunity. And you've said that the trigger for you was the 1947 post-war constitution. So prior to the constitution, what were women's rights or status under the law previously?
Well, if the viewers are sort of familiar with the common law system, it was more like femme covered by the husband once women are married. It was very similar to that, in that women are not entities, legal entities, in that unmarried women were covered by the father. The married woman was covered by husband as one, And then once she is a widow, she apparently was sort of protected, supposedly protected or covered as a legal entity by her son. So she was legally non-existent. But very, very interesting thing happened in 1933. The attorney law, or Japanese lawyer's law, allowed women to sit in the bar examination in that from that year because of the law. And there were 3 women in 1938 who passed and were trained accordingly and became full practicing lawyers. Why I'm mentioning this is something that sort of reminds me as sort of quite a parallel to the Abenomics and Winomics, how the previous prime minister tried to so-called empower women by putting women pushing them into the work forces, and saying that, and the reason the government wanted to do was the scarcity of the labor force as they foresee in the age of fewer children. And therefore, the reason it happened in 1930s of pulling women into the qualified bar was that the men were going to the war, and there were so few lawyers qualified to help defendants or represent plaintiffs. So they had to ask qualified women to join that workforce. And now again, in 2010, women are asked to join because there seems to be a lack of workforce or qualified, well, sort of high quality workforce with college, university education, who apparently go back to family to look after their children, which the government and the elite society thought was detrimental to the economy of Japan. So the whole idea of pulling in women to the labor force, because there is a sort of dearth of manpower there, sort of real manpower, so to speak.
Of women from the 1930s, at least in the legal profession, was more out of economic necessity rather than a recognition that they could bring equal talent or a unique contribution to the profession.
Well, actually, they were from very, very well-to-do families. The fact that they had gone to higher education, the top-level education, were able to sit through those bar examination, meant that they were not sort of normal family person, or they had to prove themselves in order to live. They came, apparently they were very well off, as far as I figured out from their biographies. So it's not that they felt probably they felt that they had to prove that they are as good as other people, other men of the equal qualification. But it wasn't for the money, so to speak, financial need that they had to do those things.
So what type of value change did the 1947 Constitution have in thinking about gender equality, and practically what impact did that have in subsequent law developments in relation to gender in the law?
Well, for most Japanese, the Constitution and the ideas within were sort of more or less given, rather than they felt that they fought for it. Although there were some militant women looking for their suffragette in the since the 1910s and 20s. So it wasn't, for some people, it was something that they fought for. But for many, many people, the majority felt that they had a bonanza of gift coming from. Nevertheless, they felt that they had been empowered. And it is very true that they had been empowered in a sense that, for example, in the civil code, the family code, inheritance of the portion given to women in terms of siblings, that used to be, it was only for the oldest son, supposedly, who got the whole family fortune, whereas now it is split among the siblings, female and male, in equal portion. So that was something that I think many people felt as sort of achievement or attainment that the Constitution brought. But the reality actually is that in the very beginning, not very many people sort of acted accordingly. So if you look into the family court records, you see in the 1940s and 50s or into early 60s, a lot of cases are brought declaring that the younger siblings would waiver their rights for succession so that the oldest son would have the whole family fortune. Whereas since the mid-1960s, sort of in parallel to the economic growth in Japan, and the fact that land became very precious as an asset, siblings, including women, started to ask for their portion, their parts in the family asset. And therefore, the kind of family court records changed during that period to show that there are more demand for equal portions rather than sort of wavering. So it took something like 20 years for people to realize what that Constitution actually meant. I have to say in the very beginning that in the 1947, equality of sex as such in the Constitution was very, very revolutionary, not just in Japan, but in a worldwide sense. Different countries allowed women to vote, but very few countries, I don't think there really weren't much, who had claimed to give or made it possible for women to be equal in all legal sort of sense. For example, in the United States, they still don't have it in the Constitution except for voting rights. Okay. So that sort of shows the progressiveness of the idea within that. And the effect of that was shown in, about 2 decades later, if you watch the family court records. But but it's quite difficult to sort of understand what it really means, I think, in that people still keep their ideas about the gender roles.
Following that Constitution, you have the courts now with this provision saying there's the equality of the sexes, but you also have judges. They come from the real world. They come from, they are people themselves with this, very strong, as you say, sort of rooted idea about gender roles, both in the family, also in the economy as well. So how did the courts begin to interpret Article 14 and equality, and has that shifted jurisprudentially over the years?
Yes, definitely. Until 1930s, mid-1930s, I should say, it was very difficult. Well, women were paid less, still paid less, but much less. They were not given opportunity to be promoted or even hired. So there are few cases where women asked for equal pay because equal pay was written within the Labor Standards Act, Article 4. So they had sort of some, what should I say, pegs to put into, but it was very difficult because most people assumed that, well, within the workplace, women acted differently, had different obligation, or rather were not expected to function as much as men within the workplace as sort of the main character within the labor force. So there were people who actually did ask to, first it was the early retirement cases. Women were asked to retire after 25 because by then she should have been married. And because women were expected to be tea servers and beautiful flowers in the office rather than real functioning work person. So that for those people thinking in that terms, it was reasonable to have younger women, beautiful women, serving tea to guests and whoever. So to ask to retire after she was 20, 25, whatever. And as well as if once she was married, she has the obligation to the family, rather not to the company or wherever. So these were the first cases. And it was in a time when men were to retire at the age of 50 or 55. And it seems incredibly unfair to say that you had to retire at 25. So someone did go to the court, did get the decision that yes, that was quite unfair. But the court had to turn to Civil Code, Article 90, which looked for the public order and good morale, and said that the spirit of the Constitution should be reflected in that word, and therefore the equality should be included within the private sphere of employment. So the court had to sort of bend their backs and look for something to tackle with the claim of equality. But the difference between the Commonwealth countries and Japan is that in Japan, a case is a case, it's a case, and that only affects the parties. So it wasn't going to be the social norm once the court decides. So it took many, many cases and quite a long time to find out that women could ask for and get similar treatment, not exactly the same, but similar treatment within the workforce. But it has taken quite a long time. It's not, the judges are not always sympathetic to that claim. So, but it did take quite a long time. And then came CEDAW.
Okay, so let's talk about that, because CEDAW, the Convention for the Elimination of Discrimination Against, or all forms of discrimination against women, in 1975, Japan was a signatory, which then led to the legislative initiative of the Equal Employment Opportunity Act. How significant was that, I suppose, international pressure or the international prestige that Japan had? And how much do you attribute the development of the equal employment opportunity legislation to more domestic forces?
Well, I have to say, Japan ratified in 1985, and the Equal Employment Opportunity legislation came into effect in 1986. So it was apparently in order to live up to the expectation that CEDAW had sort of presented to the affiliated countries, that Japan had to make this. So yes, it was international pressure, but also the business community was already looking for qualified women who had been who had graduated from universities and then had to leave workforce quite early in their career because the opportunity for getting work at that point was very low. Well, I remember people saying that, well, a four-year university graduate not wanted women, man welcome. So the door wasn't opened until that time for four-year university graduates. That was one problem. So this law opened up saying that there should not be discrimination in the recruitment process. But then the Ministry of Labor at that time allowed companies and other entities to set up two courses where one would lead to the managerial position, the other one would be very, very supportive, supplemental, and then they sort of nicely led people into the two different paths, like shepherds, what should I say, keeping the sheep in different paths because they belong to one or the other. So we were led into those different paths. And the paths were different in sense of responsibility and therefore pay for the expectation, the training and all that, which actually kept the two-tier system that they had it before. So the company felt that it wasn't a big deal to have that kind of new legislation coming in. Nevertheless, they were able to employ someone with real good credentials, even if they are women. So that sort of opened up a bit for women, but for the most part, women were doing the similar supporting roles within the company.
In addition to the dual track system, one of the controversies, I suppose, that attracted a lot of scholarly attention, especially in English, but also in Japanese, in the first version of the Equal Employment Opportunity Act, was its relative weakness. Sometimes it was described as a toothless tiger. Some of the obligations were expressed in voluntary terms. The only ones that were mandated were equal pay and I think retirement age, because they'd already been set in prior legislation or case law. Now, some scholars have said this is a reflection of Japanese culture, the need to catch up and to achieve consensus in society, and others have been very critical of that cultural explanation. Where do you stand in terms of evaluating the Japanese government's first effort in meeting its obligations under CEDAW?
One, I totally agree that it's toothless. And I also claim that I think it was sort of useless because it was, should I say, codification of the case laws that you mentioned. So they weren't going into new grounds and breaking new grounds. They were just doing what they had to do. One. And they didn't want to frighten the business community. So they made it really toothless in order to be acceptable to the society, that it's not a great change saying that. And that meant that they were not really living up to the promises that they made in ratifying the CEDAW. And also that meant that we are sort of kept back in progress to the equality and the gender equal society. Although they claim that they are looking for that, but it wasn't really true. So I'm very, very critical of how they have done. And also I must mention that some of the business elite were looking for to have this law or something a bit stronger even, because they wanted to recruit very well qualified women into the managerial position that they saw as sort of being wasted at home. So they sort of pushed the image that now women can work like men. No, thank you. But nevertheless, the average people saw it as sort of the chance for women to start working.
There have been two major revisions to the legislation since then in the mid-1990s and then again in the mid-2000s. In your view, have those revisions added more teeth to this tiger? And where do you think there are, or in addition to that, where do you think there are still current problems with the law?
Well, yes, they have added a little bit each time it was amended. For example, sexual harassment, the concept of sexual harassment was put in the second amendment, First Amendment, and in the Second Amendment, I think the main idea was a reference to indirect discrimination, although it wasn't really sort of defined as such, and that it was hoped for that people would realize that there such thing was not a really good thing, to put it very, very mildly. Little by little, different provisions were strengthened. And in the 1999 2000 amendment actually allowed it to be more of equal opportunity for women and men rather than just for women. So, which also tied up with other labor legislation such as family leave for child care and elderly care, and it allowed males to take those leaves. So the posture was that now women and men are in an equal position, but nevertheless, the latest statistics I hear is that men are taking childcare leave, the average being 5 days. Mm-hmm. Whereas women, the average I heard was something like 8 months or so. Mm-hmm. So it sort of start to show, even if men are allowed or could take or have the right to take leave, they don't use it, or they feel intimidated within the working environment to claim for that kind of leave because of that kind of very strong gender role assumptions.
In addition to the employment context, sort of more recently, around the late 1990s into the 2000s, there's been some basic laws and initiatives to encourage more women in terms of public policy making and in leadership and management positions. So what type of initiatives have there been, including former Prime Minister Abe's so-called womanomics strategy? Mm-hmm. So what have those initiatives been, and how would you rate their success or failure?
Well, it was wonderfully written, and the country reports that Japanese government present to the Commission on Women's Status is that they are doing all they could and they're living up to the expectation. The reality, it's all beautiful words, and they're not lying. There are those projects, but it's very tiny and it's very ineffective. So there is still that kind of expectation for women to look after and care for the family members in whatever situation they are. And that is reflected in the small details of the everyday life. So the writings that the government present is no, I'm not saying they are untrue or false. They are true in a beautifully sort of written way, but they don't reflect the reality, what is going on. Yes, going back to the was it a women shining in the world idea of the Prime Minister Abe? Well, he tried to put women, it looked to me as more or less like a token. Because I think in the year 2005, the Japanese government said by the year 2020, there will be 30% of women in every area of leadership, including, of course, the members of the parliament and the judiciary and everywhere else, even in the private sphere of the companies. They were expected to have directors and other people in the sort of leading position, 30%. And they thought that in 15 years' time, that would be achievable. Lo and behold, this is year 2020. And well, first, let's look at the House of Representatives. It barely keeps 10%.
Of young women today, though, I mean, you work at a law school, there have been increasing numbers of women. It's still around 30%, I understand, who are applying for law school. Do you see those numbers increasing, or do you see 30% as roughly the pattern for the next few years? I mean, in Australia and the United States, women are 50, even 60.
Over 50, yes.
Why in Japan are women less reluctant to think about the law as a form of education and as a possible career?
I remember when I was a graduate student, the dean of Harvard Law came over, and because there was only one woman in the graduate studies, I was asked to have tea with him when he was visiting. And he mentioned that, yes, we finally got 30%. 50% is just a few years ahead of us. We have had 25 to 30% women in the faculty of law undergraduate, as well as it for, I don't know, about 20 years, 25 years. And also, the law school began with something like 25 to 30% in 2004. And the number hasn't increased a bit for the past almost 15 years. The reason, and therefore I don't see a very near future of the increase of women there. The reason I don't really understand is that, well, quite a number of people mention that women tend to think of getting married as quite an important thing, and doing extra studies and doing the trainee stuff sort of delays women from getting married, which really isn't true, because a lot of people do get married in the graduate school or during the trainee sessions, or rather, it's the more or less the only chance where you do find peers, men of the same age probably, around her. Once you're in workforce, it might be more difficult to find a person similarly situated and would understand her situation.
Those women, so you've talked about women and, the reasons why the application rate is around 30% to actually get into law school. But for those who do, there seems to be a trend that more women prefer the public sector legal jobs, such as the judiciary and the procuracy, and fewer are entering private practice. But focusing on the judiciary, there has been some research that shows that the judiciary basically self-enforces and self-polices itself. And Professor Haley, for example, has described it as a relatively conservative judiciary, but one that is nonetheless effective. For women who enter the judiciary, does that sort of conservatism influence or affect their experience as a judge? Do they feel that this is a satisfying career, or have there been thoughts that there are still barriers even within the judiciary in terms of achieving career success?
Well, conservative could mean many things. One thing is that they stick to the meritocracy. So if you did very well in the bar examination and what they call the second exam, graduating from the training institute, if they did very well in those, going to judiciary means you do have a very good chance, regardless of your agenda. Mm. So women could, if she could prove that they are up to their expectation, get the job. It wasn't true 40 years ago, because I knew several people who were sort of asked to get into the family law areas. And there weren't that many to start with, but all went to become family court judges. And the leading person in that area were sort of jumped from the district family law court chief judge of that to the high court chief judge. So it was a jump that, I mean, everybody knew she was very bright. She's been a leader of the family law, and they probably felt that she had to be rewarded somehow. So she jumped to become Sapporo High Court's chief judge. But that was really exceptional. Things changed within 20, 30 years. There were several female justices in the High Court, Supreme Court as such, and which also allowed other female judges to go into the area of sort of that was open to the other exceptionally qualified judges. So in that sense, because the standard didn't consider about being male and female, they were given a chance to be promoted as long as they sort of adhere to the all these political leanings and thoughts. If you had stand out as a very progressive left-leaning person, well, you probably didn't have a chance. But if you are fairly conservative in big C and small c sense, and then you probably have a very good chance of being promoted to fairly good positions. So, and the public sector also is very attractive in terms of child leaves and all these family sort of care positions, in that they could ask for leave and get it fully sort of, because they are covered by Constitution and all these, their position would be very much protected, as opposed to private sectors. Until the introduction of the 1990-something, 92, I think, Child Care Leave Acts, it was very difficult for people in the private sector, especially lawyers, to take child leave. I have heard several people who had left the hospital after delivery and then went straight to the office because she had her clients waiting. On hearing all these sort of episodes and stories, for young women, it's quite frightening to go into private sectors. It has become better because there are more women And that means that they have to accommodate that kind of request in order to keep very bright women in their law firms. So it has become better, but you could see that in judgeships or in prosecutor's office, you are guaranteed in law to get those kind of leaves. So for lots of women who had been done quite well, the public sector is very, very attractive.
Finally, to conclude, we've had a wide-ranging discussion about gender in the law, way back before the Constitution up to the present day. 2020, of course, the COVID-19 pandemic has really affected the globe, affected Japan as well. What type of issues affecting women, whether in employment, family, criminal law, or social status generally, has this pandemic sort of brought to the fore? Or what type of future issues do you think will emerge as a result of this COVID-19 pandemic?
Well, actually, the first point is that the government has been very reluctant in producing gender statistics. So it has been very difficult for many people who are concerned to find out the real effect the COVID-19 had on women. We know that temporary workers are laid off. And we know that the majority of that are women. But without all these statistics, we don't really know what was the real impact within the society. We do hear and we do realize lots of sort of anecdotal information that was happening, or that not just that they were sort of sacked. Some people, for example, refrained from going because, for example, they had elderly people within the family, and therefore they don't want to expose themselves to the virus and go back home. And therefore they ask for a leave, a very long leave. Eventually they are fired, I hear. But that kind of things doesn't sort of occur to the man's mind in Japan, apparently, even if they are in a similarly situated. Some of the statistics, the researchers had revealed that a lot of people were working from home, men and women. Nevertheless, women apparently are doing about 5 times as much of the family work within that same situation as men, according to some of the researches done by a professor in Kyoto University, for example. And I think that's a small sample, and that having both people within the family to do sort of at-home working situation means that they are in a very well-situated company, very well paid, able to provide all these sort of computers and such for individual people. That means that they're really well off within the Japanese society. Nevertheless, those people answer that, yes, he is sitting there doing games while I'm cooking. A very, very typical sort of situation. On the other hand, recently, I've noticed that a lot of young fathers are looking after toddlers, sort of taking walk, playing with them in the daytime, apparently because somebody has to look after, and that the daycares are not available or had difficulty gathering those who would care for those toddlers, for example. So the younger generation families are doing fairly sort of good sort of share works within the family. And I think the problem becomes greater as the people become, or for the older people, not meaning the people, aging people, but in the 40s and 50s, they couldn't really adjust themselves to the new idea of sharing domestic chores. So things are actually changing from the younger generation. You sort of mentioned about the last name surname phenomena. Why is it really issue? It is changing for the younger generation, and people are accepting or thinking that, well, what's the big deal about allowing people to select whichever last name they want to use. But those over the 40s, they don't think it's proper, or at least the majority thinks it's not really proper, even to allow selecting. It's not sort of forcing people to keep their last names when getting married. It's the more sort of like allowing people who want to do is really the end of the world as they know it. Maybe it is, but but nevertheless, sort of there seems to be a huge generation gap in seeing how sort of gender works within their family or in the society, between something like over 40 and under 40. And I certainly remember the days when in the late 60s and early 70s when young leaders said that don't trust people over 30. So maybe that's repeated again.
Okay, well, thank you, Professor Kamiya, for appearing on this interview and discussing your personal observations, your research interests, also your engagement in public policy in relation to gender and the law. It's been a fascinating conversation. As you know, COVID-19 has meant the 2021 Kyoto and Tokyo seminar series has been cancelled, but we hope to be back in 2022, and we look forward to hosting you again as an expert lecturer in gender and the law. So once again, our appreciation and thank you for your time.
And thank you for inviting me over for the conversation. It really was very enjoyable. Thank you very much.